All right, good morning, everybody. I think we're having a few people to roll in here, but I think we'll go ahead and get started. Welcome to our webinar on OSHA changes related to COVID-19. Thank you all for being here. My name is Noah Hock. I'm here with my colleague, Natalie Sanders. We're looking forward to sharing this information with you this morning. Quick disclaimer for you before we get started. Please note that the content of this webinar is provided for general information purposes only. It should not be considered legal advice and used as any substitute for consulting with an attorney for legal advice regarding your own matters or issues. I'll also note for everybody, just as a detail for later, this webinar is being recorded. So it will be posted on our website, brookspierce.com, as a news item probably tomorrow. It will also be sent as a link to all of you as registrants here, along with a PDF version of this PowerPoint. So no need to take notes or anything. If you'd like, we'll be sending all this information to you later. Just a quick roadmap of what we're going to cover today. We'll start with a little background about OSHA, kind of where it's, what it does and what its standards, how its standards are imposed. I'll start with that portion, and then Natalie will jump on and she'll talk a little bit about OSHA's COVID-19 response, both so far and what we might expect to come in the very near future. And then I'll jump back on and talk a little about the enforcement process or what may happen if a complaint is filed with OSHA. And then we'll leave some time for questions at the end. However, please, if you have any questions as we go, please enter those in the chat. We'll be monitoring the chat as we go. And if there are any questions that are particularly pertinent to what we're discussing at the time, we may jump in and discuss those. Otherwise, we will, like I say, leave some time at the end to address any questions that have popped up. So as I said, OSHA, the Occupational Safety and Health Administration, is a federal organization. It was created in 1970 as part of the Occupational Safety and Health Act of 1970. It was designed to ensure safe and healthful working conditions for working men and women in the country. It covers most private sector employees and workers throughout the United States. And it's a federal agency. It's housed under the Department of Labor. However, a number of states opt to manage their own OSHA departments. And they have the option of doing that. However, the state agencies must provide at least as much protection as federal OSHA, though they may have the option or may choose to select or offer more stringent standards. North Carolina is one of those states that offers or operates its own OSHA department. However, North Carolina's standards generally mirror the protections and standards provided by the federal OSHA system. So OSHA manages itself and manages about three specific things. It's kind of what it does on a daily basis. It sets and establishes workplace safety standards. It responds to complaints and inspects workplaces for safety compliance. And it provides training and education resources related to safety in the workplace. We're going to kind of discuss the first two mostly. We're not going to touch a whole lot on number three, but it's always worth reminding and remembering that if you have safety concerns or questions, often there are some great resources, both at the federal and the state level, OSHA departments. It's always worth looking or reaching out if you have specific questions. So to move into the safety standards, OSHA manages or establishes safety standards in two specific ways. First, they have specific targeted standards to address safety in a given industry. These can be very detailed standards. And if you work in an industry that is subject to a number of these standards, you're very likely aware of these requirements already and may already have some regular discussions or correspondence with OSHA in that regard. One example that might be pertinent to our COVID-19 discussion today, OSHA sets very specific rules for when respirators must be used in the healthcare field, for example. However, specific standards are only part of what OSHA relies on. They also rely on what's called the General Duty Clause. This is a statutory standard that was established with the OSHA Act of 1970, and with some apologies for the gendered language based on the fact that it was written in 1970, it states, Each employer shall furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his employees. So this kind of operates as a catch-all standard that addresses some safety concerns that may not be focused or covered in a specific standard that OSHA has already promulgated. And so based on these OSHA standards, they apply to the workplace response to COVID-19 because of this general duty clause that can cover any potential issue of safety, as well as through some specific standards in certain industries.
Thanks, Noah, for that great introduction. So I get the pleasure of talking to you about the specific things OSHA has done with respect to COVID-19, where we are, where we've been, and where we're headed. So given the role that OSHA is supposed to play in our workplaces and their goals in the general duty clause, we all kind of thought OSHA would be the primary resource for employers when the COVID-19 pandemic hit. And that did not turn out to be the case. Instead, as you all know, we've been really guided by the CDC and our state health departments and our local health departments. But OSHA did issue a guidance document, and I've got the cover of it here on the screen. So it was their guidance on preparing workplaces for COVID-19. And some of you may have joined us back in the late spring, early summer. We did a presentation about how to have people working in the workplace during COVID. And we went through this in a lot of detail. And the primary thing that this guidance called for was an infectious disease and response plan. So some of you may have remembered that. Some of you may have implemented that. But now you'll see that at the top of this guidance, even though you can pull it up on the internet still, it has a little bit of a disclaimer, basically telling you this may not be the latest guidance. So that's where we were. Now that's no longer the latest. What's happening? Well, we had a change in administration. So on Biden's first day in office, he issued an executive order with some very specific instructions to OSHA. And he asked OSHA to consider if an emergency temporary standard is needed to deal with COVID, and if so, to issue it by March 15th. So we're past March 15th. That deadline came and went, and we don't have an emergency temporary standard. So why is that? Well, there are a few reasons. First, an emergency temporary standard skips the normal notice and comment period and immediately is implemented. And there are procedures and rules and statutory language that say when OSHA can do that. And in order for OSHA to do that, OSHA has to make a determination that employees are exposed to grave danger and that the standard is necessary in order to protect employees from that danger. So before the Biden administration, we have OSHA on record saying that an emergency temporary standard is not needed. And so there's actually a court case where you had labor organizations trying to force OSHA to act. But the district Court of Appeals agreed with OSHA that they had reasonably determined that at that time, an emergency temporary standard was not necessary. And so it didn't go any further under the Trump administration. Another reason, it's hard to meet that standard. The last time OSHA really tried was in 1978 with regard to asbestos. And that emergency standard was invalidated by the Fifth Circuit, saying it didn't meet the high bar that's needed to issue it. So it's hard to get this done and to justify skipping that notice and comment period. So what's the likelihood that we're going to see an emergency temporary standard? Well, if you'd have asked me 3 weeks ago, I said it was very high. In fact, it's coming. And in fact, we planned this seminar for you thinking it would be here by now. So it's different than 3 weeks ago. Well, 3 weeks ago, we had things in the news saying that OSHA had decided that it was necessary and had in fact begun drafting things, and that it was in fact already with the White House Office of Regulatory Affairs Review. So that's where we thought we were. There were news blurbs saying that. Then last week, we have a newly appointed Deputy Assistant Secretary for OSHA, Joseph, he goes by Chip Hughes, and he was in a press conference and he said, no, we haven't made that determination yet, but we are working on the standard and we do hope to move it to the next level soon. He left open the option that it wouldn't be something that covers every employer. They may do something specific to the health industry and have something for other employers, or they may focus on healthcare. So that's last week. This week, asking me my crystal ball opinion, I'm starting to doubt that OSHA is going to do it. And part of that is because we're seeing so many people get vaccinated and the availability of the vaccine, we're seeing things moving in a direction where justifying that emergency temporary standard as necessary to protect from a grave danger that employees are in fact exposed to in their workplace, it's going to get hard to meet that standard. So I'm not sure if we'll see it. Long term, will we see something? I do think so. I think under the Biden administration, we're going to see something that, if it's not directly targeted at COVID, will be targeted to COVID-like situations in the future. And I think what that means is that for those of you who aren't in higher risk industries, you're not in a manufacturing setting, you're not dealing with chemicals, you're not in the healthcare setting, maybe you're just in an office setting, and so you don't feel like you're dealing with OSHA on a daily basis and it's not at the forefront of your mind. You don't have posters up marking the number of days without a workplace accident. You're not one of those employers. I do still think you're going to see more OSHA involvement in your workplace. Now, all of that said, OSHA did act in response to the orders from Biden, because one of the other things he included in his order wasn't just the evaluation of the emergency temporary standard and issuance. He said, improve the guidance, okay? He gave them a February deadline, can't remember the exact date, but they acted very quickly. By January 29th, we had a new guidance document. And this one is entitled, Protecting Workers, Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. What does this guidance say and how is it different from what we had before? Here are the key things. Number one, face coverings are really emphasized in this guidance as a way to protect the workplace. And looking again into my crystal ball, I think we're going to be seeing face coverings in the workplace for a long time to come. And if you've looked at the news and seen what our use of face coverings has done to the flu season this year, it's incredible. So I think face coverings might be something that's here to stay, and we might see in the future in some sort of workplace standard for different situations from OSHA. The guidance also calls for employers to implement COVID-19 prevention programs. So that long-term we were looking at before, that infectious disease prevention plan, that's out the window, that wording's out the window. And so now it's called the COVID-19 prevention program. So if you did implement one of these infectious disease and response plans, go ahead and relabel it. And then you can update it based on this guidance and the things that we're talking about today. This guidance really improved the detail and format over the prior guidance. The prior guidance used a lot of verbiage that if you were familiar with dealing with OSHA on a regular basis, probably made sense to you, but it wasn't very user-friendly for the work environments that were not regularly dealing with OSHA standards and guidance. So that's a big improvement on the guidance. This guidance also uses some stronger language. It's still not must, it's not a standard, it's not required by law, but it has a lot of should statements. Employers should. And so it has a lot stronger implication. Most of what's in there mirrors the CDC guidance. There are a few areas where it goes a little further or clarifies some things that you might have been wondering. And this guidance contains a couple promises, and they are significant ones. OSHA says they're going to update it to reflect the latest developments, whether that's science, best practices, standards, and they're going to somehow track the changes for you. They're going to tell you where they've made the changes so that there will be transparency in what they do. That's going to make it easier. So, you know, thinking of what we had as guidance and now we have this new document, they didn't do the track changes for us there. So they didn't highlight exactly where our changes are. But for this one, they say they're going to do that going forward. And the other thing is they're going to focus on particular industries and workplace situations over time. So that's great news from OSHA. Now, let's talk about some of the specifics in this guidance so that you can look at what you're doing right now to prevent COVID in the workplace and take a look. Am I doing what the latest guidance says? Well, the first statement they make is that implementing this workplace COVID-19 prevention program is the most effective way to mitigate the spread of COVID-19 at work. So if you get a complaint by one of your employees and OSHA does give you a call or you get a letter from OSHA, what do you think the first thing OSHA is going to want to know? They're going to know what your COVID-19 prevention program is. So this is not mandatory. This is not an emergency standard, but this new guidance is out there. Highly recommend that you dive into it. What does it say? It's going to say a lot of things you've been hearing already, but it has some twists. Number one, OSHA is really encouraging you as employers to engage the workers, engage your employees in the process of developing and implementing the program. OSHA really takes a view of protecting employees and that employees know what they need protection from. So if you haven't engaged your employees and gotten some feedback there, suggest doing that. OSHA wants you to assign a workplace COVID coordinator, someone who's not primary job, but at least someone who is responsible for monitoring and carrying out this prevention program. And then identify where and how workers might be exposed. This is a hazard assessment, and it is based on each particular position. So it's not your whole workplace applies to everybody, but each person may have a different level of exposure. You may have someone who deals with the public, who is your reception person, and everybody else is working in offices behind them. So that person may have a different exposure risk than people working in their private offices and not seeing anybody from the public. So how do you make that hazard assessment? Well, there's a link in the guidance to the OSHA hazard assessment document. I will tell you though, that that document has the same disclaimer at the top of it right now that the original guidance that OSHA put out. So they're telling you this may not be the latest, but they haven't given us something else yet. And there still is this link in the current guidance to this form of hazard assessment and risk exposure. So what does it look like? Basically, you're going through and you're examining each job and you're saying, is this person in a very high risk situation? Are they in just a high risk situation? And they give you some examples, some guidance for making those determinations. Then medium risk. And these are the people who really have interaction with the general public, or they have to travel in their work, or they may have close contacts or frequent interactions with people that they don't know whether or not they might have COVID. So that's your medium risk. And then you have your lower risk. Really, your job doesn't have much to do with contact with other people. And it really has limited contact with your coworkers. So these are going to be situations that are more office oriented, more likely. All right. So once you do that assessment, then what do? You identify what measures you can put in place for each of those different type of positions and exposures to limit their exposure and limit the spread of COVID-19 in your workplace. What does that look like? Well, these are some of the things that they identify in this guidance. And again, these are things we've seen from the CDC. At this point in COVID, these shouldn't be new to you. But having a specific plan for separating someone who is potentially infected or who is ill, separating them from the other employees, and then a specific plan for how you're going to get that person out of your workplace. And that's something we don't all think of, having to have a plan in place. Kind of seems obvious to us at this point. But again, OSHA's telling you the best practice is to have this program. So think through this. What are you going to do if you suspect someone? Physical distancing, social distancing, we all call it. That's the maintaining 6 feet from each other. But it also includes, according to OSHA, remote work and telework. So as you're going through this guidance and thinking what might be in a temporary emergency standard or some standard they put together in the future, this is giving us a hint that they think maybe remote work might be here to stay. So just be thinking about that. Installing barriers. We've gotten very used to the acrylic barriers, and people have gotten real creative in different workplaces about how to make that happen. Using face coverings, I've mentioned that that's prime for OSHA. Then OSHA also takes the view that you really need to evaluate not just the immediate things you can change, the things that you can bring in and do something about or plan for, but you need to actually evaluate your facilities themselves. Evaluate how you might improve the ventilation system, evaluate your air handling system. Take a look into those things. Where it's appropriate, especially healthcare, use appropriate personal protective equipment. And then this is another key element that you didn't see just by looking at the CDC guidance, but that OSHA uses the should language again. That employers should be the ones providing all of the necessary supplies, including your face coverings. So if you're allowing people to use their own face coverings, just have in mind that OSHA says employers should provide the face coverings. That's a little different. And then perform routine cleanings, disinfections, and there's a whole lot more. In addition to all of those things, they put out some factors like looking at the people who might be high risk for severe illness in your workplace and considering modifications for them. That's great guidance from OSHA. Not sure exactly how that interacts with all of the obligations to not single people out, not treat people differently because of their age or a health condition. So while OSHA's recommending that, we're also saying balance that with what you already know to be the case and how you have to protect those people and treat them the same. Communicate effectively about the flexibilities and protections that you're doing. Noah mentioned that one of the key things OSHA does is training and education programs and providing those resources. So it shouldn't be surprising that they have in their guidance that employers should be educating and training employees, right? Then the things about instructing employees when it's appropriate for them to isolate or quarantine. We've gotten really pretty familiar with this and also familiar with the fact that it's a moving target. These guidance and guidelines change from the CDC frequently, including right now we have the CDC saying that there's an alternate standard where in certain circumstances you could change the quarantine period from 14 days to 10 days and even down to 7 days if the person gets a test and it's negative 5 days after their exposure. But that actually is something that is for local health departments to decide. And so if you're in North Carolina, you're going to want to check with your local health department, because there are some health departments that are expressly saying we're rejecting that option, and an appropriate quarantine for an exposed employee is still 14 days. We're sticking with that conservative path. And there are others that have said, yes, we're adopting that CDC option. Go ahead and carry it out. There are even others who have said, not quite, we'll take it down to 10 days, but we're not going to implement that 7-day option. So there's confusion there, but OSHA is telling you, try to educate on it. Then minimize the effects of quarantining or isolating. What does that mean? Again, that's our remote work from home, allowing people to have the opportunity to work from home if they're still well enough to do so. It also means taking into consideration the flexible work schedules. How might you be able to provide them the time off that they need and still get work accomplished? Having that flexibility. Isolating workers who show symptoms at work, that's very similar to the person who's been exposed. Enhanced cleaning and disinfection. And then guidance on screening and testing. All right, they also want you to report. Those of you who deal with OSHA on a regular basis, this is going to be familiar to you. But for those that don't deal with a lot of workplace injuries or illnesses, keep this in mind, that COVID-19 is considered an illness that, if it happens in the workplace, is going to be a recordable workplace illness or injury. So who has to do this? How do you have to record? You have to basically try to figure out, did they get it here at work, right? Is it work related? And if it's more likely than not that it was work related, that they got it at work, then what do? Well, you're going to have to report or record if there's medical treatment and they've had time away from work. Of course, if there is a death, that's going to have reporting versus just recording obligations. All right, final few things that are called for in your COVID-19 prevention program. They want you to implement some protections for people who report. Of course, there is an anti-retaliation obligation. We'll talk a little more about that. But they want you to set up an anonymous process for voicing concerns. To my knowledge, very few employers have that set up at this point. And again, we're telling you about it. These are shoulds from OSHA, not an emergency standard at this point. Another thing they specifically mention is making vaccinations available to employees at no cost. Currently, vaccines are available to all of us through the government at no cost. So that one's an easy one to hit right now. Where that will be in the future, we don't know. If there's some future standard that is going to require employers to make vaccines available to their employees at no cost, these things may be hinting at future things that OSHA may want to implement. And this last point, I think, is significant right now. Do not distinguish between those who are vaccinated and those who are not. So OSHA is specifically telling you that you need to go ahead and, even if someone's vaccinated, even if the CDC has guidance out there for what vaccinated people can do now, that doesn't mean it applies in the workplace. Instead, workplace, whether you're vaccinated or not, you're still following all of the protocols. So we aren't at a point to make those distinctions yet. All right, I have a couple of final points on OSHA's activities right now. In addition to putting out the guidance, they changed how they're going to focus their enforcement. and they have a national emphasis program now. And what all of this means, if you're not familiar with OSHA, is how are they going to carry out their enforcement obligations? What does it look like? So they have programmed inspections. And programmed inspections are, they've prioritized certain high hazard industries and activities. And I've put a list up here of the most prominent ones right now and said, we're going to focus on these, right? When we go out and make our inspections and we're programming, where are we going to go make our inspections? Where are we going to show up unannounced? These are going to be the industries. Then the unprogrammed inspections. These, they're going to focus on, these are the more responsive things, where programmed is more proactive, the unprogrammed is more responsive. So they're looking at where have there been COVID fatalities and hospitalizations reported, and then where has someone, an employee most likely, reported insufficient controls and exposures in the workplace. So those are going to be the unprogrammed, the responsive areas. And then the final thing that they prioritized in all of this was whistleblowers and the protections for those who do raise a concern or complain. So all of those things that they've implemented, the National Emphasis Program and their Memorandum on Enforcement, this is their goal: to conduct inspections in a manner that is going to achieve the issuance of COVID-related citations and abatement in the most expeditious manner they can. So that's their goal. So a couple things within that goal that they have said: if it's a programmed inspection and the inspector finds that the work assignments don't fit, once they get that initial information, they don't fit the categories for the programmed inspection, or there are no cases of COVID that have occurred, they're going to stop their inspection. If it's an unprogrammed inspection, that means someone has complained, there's been a fatality, there's been a hospitalization, then even if there's no initial evidence of the COVID exposure, their inspection is going to continue. And then they're prioritizing enforcement for employers that are not making good faith efforts to protect their workers. And actually, this little piece of enforcement guidance came out pretty early on, an enforcement memo to all of those inspectors. And it basically said, look, if you're finding that the employers are making good faith efforts, they're not on our priority list. We really, we need to correct things if it's not being done right. We need to give them their notice that we need to do things, but our enforcement priority is going to be on those who are not making good faith efforts. So if you don't want to be on the naughty list for OSHA and you want to show your good faith, you need to implement one of these COVID prevention programs. I'm going to flip it back to Noah for the enforcement process. Unless, Noah, have you noticed any questions coming up for me?
Yeah, I was going to say, Natalie, there's one question that you might be able to address. It says, regarding reporting a case to OSHA as a recordable, how can a company definitively conclude that the exposure was an internal exposure and not from an external source? Is it a situation where assumptions should be made with no control over how people utilize PPE outside of the workplace? It seems this is a strange gray area.
Yeah, that is a very good observation. I'll speak a little bit to that. The OSHA has some good guidance. So if you go to their website, they have some guidance on how you go through the process of trying to figure out whether or not it was work related. And I think it's in one of the enforcement guidances, because it says that the inspector, one of the things that they will do is they will look at, what did you do to try to figure it out? Did you make that good faith effort to try to figure it out? So you want to have had a process set up where you're asking employees, what did you do outside of work? Is there some place you might have been exposed other than at work? Ask employees, is there anything that makes you think it's more likely you got it here than anywhere else? think through some of the questions that you can ask. And if you come to the conclusion that, okay, there were some in here who had COVID, but this employee, it hasn't had any close contact exposure. They've been wearing their mask, they've been 6 feet apart. Doesn't seem likely, given what we know about COVID, that they would have been exposed at work. And when you ask them about outside of work, well, yes, I've been going out and I've been eating at restaurants and all of those kinds of things. Well, when you're out at a restaurant with friends who aren't in your household, you have your mask off and you're probably within 6 feet of each other. So is it more likely they got it at work or not? Probably not, right? So unless you can conclude it more likely happened at work, if it's equally likely to have happened somewhere else, then concluding that it's not work related, I think is a good position. But it's case by case determination.
Thanks, Natalie.
All right.
I'll move on next to talk a little bit about OSHA's enforcement process. As Natalie mentioned, because of kind of the unprecedented nature of the COVID-19 pandemic and our response to it, we're anticipating, and I think it's likely that many employers may find themselves interfacing with OSHA in ways that they haven't before or for the first time even. So we'll just walk through a little bit of how this process works. And so while OSHA does conduct some of these independent investigations, perhaps as part of this national emphasis program or just as its regular operating system, the much more likely process is that it will end up discussing things with an employer after an employee has filed a complaint. And OSHA generally will respond to these complaints with either an on-site inspection or more commonly, an off-site investigation. The federal OSHA offers this kind of rundown of their procedure for an off-site investigation, that they will receive the complaint and interview the employee making the complaint to determine if the allegation is sufficient to warrant an investigation. And if that's the case, they'll appoint a neutral investigator and they will notify the employer of this complaint. And then at that point, of course, the employer and the employee are able to submit evidence related to the allegations. The employer will submit a written defense to the allegations, and both sides could have the opportunity to rebut the other side's position and just basically discuss what happened or what didn't happen. And then the investigator will then make a recommendation to their supervisor about what to do next, whether a citation is warranted or not, and where to go from there. And now I said this is the kind of federal process, and if there's a state like North Carolina that has its own OSHA program, that may differ slightly. And what we would like to do now is actually discuss, walk through what you might expect if a complaint is issued or is sent to North Carolina's Department of Labor, Occupational Safety and Health Division, or what I'm just going to call North Carolina's OSHA. We put together this sample, I should say Natalie put together this sample letter based on some actual letters received from the North Carolina OSHA that were related to, in this case, a COVID-19 related complaint. Now, it's worth noting from the very beginning that this is not a citation of any kind, and there's no penalty or fine being issued here. It's just a notification and an invitation basically to interface with OSHA about what to do next. So to walk through, we're just going to take a kind of a quick walk through exactly what is in this letter and kind of more importantly, what's not in this letter. So it begins with just a notification that a complaint has been made. It gives a little bit of detail about what kind of complaint, and this as it relates to coronavirus disease 2019, which is the illness caused by the coronavirus. And it was at this establishment on XYZ Road in Greensboro. So trying to give you kind of some basic information about where or what the complaint is related to. There's also going to be a brief description of the details of the complaint. It's worth noting, of course, that these details are going to be based on the filed complaint itself before any response by the employer. So it's just worth keeping that in mind as you read this letter. The next thing we're going to see is just some information and some guidance that's related specifically to the area of concern that was raised by the complaint. It's important to take note of this information. So in this case, since it was a complaint related to COVID-19, we see links to OSHA's COVID-19 website, the CDC's COVID-19 website, some specific information related to healthcare workers, as well as the North Carolina Division of Public Health, and some details of the stay-at-home order that was issued by our governor. So again, it's worth checking these details, reading the websites that are linked, because this is the kind of information that OSHA is going to be using when it's determining what response to have or whether the employer's response is sufficient or warranted. This next paragraph is discussing kind of the instructions for what's going to happen next. In this case, as I said, is most common. OSHA is not conducting an inspection at that time. However, since allegations have been made, it's asking the employer to investigate the alleged conditions and make necessary changes. This is an opportunity for the employer to review what they're doing, look at their policies and their processes and what's actually going on, and if necessary, make those changes proactively. Of course, it also says that within 7 working days, OSHA is expecting a written response, and that response should be relatively detailed. It should state specifically what actions are being taken to correct any hazards that were discovered. And it should also include supporting documentation, monitoring results, equipment purchases, photographs of the area. This can be a very detailed and somewhat onerous process, but it's the employer's opportunity to make their case essentially and try to get back, if changes are needed, to get those changes done and show OSHA that, again, as Natalie noted, you're operating in good faith and doing your best to stay within the parameters of the requirements of OSHA. The next section here, again, is going to touch on a few more things at the end of the letter. We're going to discuss this again a little more in just a moment, but retaliation against the complaining employee is, of course, prohibited and is statutorily prohibited. Again, this letter notes that it is not a citation, it's not a notification of penalty or any kind of fine being issued. However, prompt response is required, and of course, any lack or failure of a response could have some additional consequences. So it's important that this letter is taken very seriously and acted upon immediately. And then finally, there's some instructions for submission and dissemination of the response. And I'll just highlight here that it notes that you're requested to post a copy of this letter and your response to it, where it will be readily accessible for review by your employees. So it's just, again, worth noting that and bearing in mind that this process will have a level of visibility to it because it is a complaint that was made by an employee, and OSHA takes the stance that the employee and your employees in general are entitled to some notification and some information about your response to it. So just quickly, a few takeaways that you can, from kind of reading through this letter and looking at it. Again, it's worth noting this is not that this complaint letter, receiving a complaint letter like this is not really the end of the world necessarily, but it requires a prompt and careful response. It's not a citation, it's not a penalty being issued. Again, I take it as an opportunity to work with OSHA to correct any issues that there may still be or safety concerns there are in the workplace, and resolve those issues promptly and proactively, as opposed to waiting to be fined or cited in some way by the organization, the institution. And then, of course, a reminder again that you can never retaliate against a complaining employee. And so to touch a little bit more on that retaliation piece, just briefly, it's just important, again, it's just valuable to reiterate that you cannot retaliate in any way against an employee filing a complaint with OSHA regarding workplace conditions. And then retaliation can take a number of forms. It's really any adverse employment action as a result of a complaint. So it's the obvious things like firing an employee or laying off an employee or failing to rehire someone, denying overtime or promotion, obviously the sort of overt intimidation or harassment, reducing pay or hours, But more likely this can come in more subtle ways, like ostracizing an employee or giving a poor evaluation that maybe wasn't warranted or you wouldn't have given before the complaint was issued. But again, it's just worth keeping these things in mind and being very careful how you respond to these things and how you interface with your employees after such a complaint's been made. And I'll note that if you are considering an adverse employment action against an employee who has recently filed a complaint with OSHA, and this action is maybe not related in any way, just be very careful that you're documenting the reasons for your action. Ensure that there are legitimate reasons and they're not in any way colored by the fact that an employee may have complained to OSHA about some standards. And of course, we're going to recommend that you consult with your friendly neighborhood employment lawyer before you take any action. It's just always a good idea in a situation like this. I think that comes to the end of what I had to say, but we've got some time left, as we said, for some questions. Natalie, has anything come through? I don't know if we've had any new questions, but if anyone would like to drop something in the chat now, we'd have a few minutes to discuss.
I don't see any new ones popping up quite yet, so we'll give it a minute in case any do. In the meantime, just to comment for those who haven't received one of those letters saying that someone has complained, you're lucky because they're actually getting quite common. We have had a lot of, we've seen a lot of these being issued. And don't over stress if you get one. OSHA, as best we can tell in North Carolina, is just really trying to find the facts. And we've helped people walk through, use pictures. They really want to see that good faith effort. And so if you're engaging in that good faith effort, most likely when you get one of these letters, doing a thorough response, and if there is something to change, changing it. That will be the end of it. They may follow up and check on it, but we're seeing them react to the responses pretty favorably when the employers take them seriously and are thorough and prompt in responding. Oh, I see a question has popped up. What about taking temperatures for employees who are coming to work? Is it still something that we need to be doing? That is going to be specific to the particular workplace situation, I would say. If you started out doing it, you probably did it because you thought it was the right thing for your workplace. You probably have people who are working close together, or you are interacting with the public regularly, your employees are. And so it was a good decision for you. I would say the guidance that we have right now, if it was a good decision then, it's still a good decision. Until we see the CDC or OSHA kind of pulling back in response to our hopefully getting closer and closer to herd immunity, I wouldn't recommend changing it. That said, it doesn't mean that it's wrong per se to rethink whether or not it was the right thing for you. Sometimes we're in the thick of it and it's our reaction and we don't have a lot of science yet. But at this point, it may be you could step back and do what a lot of employers did, which say, I'm not going to take people's temperatures, but I'm going to rely on my employees to self-assess every day before they come to work, which would include telling them, take your temperature before you come to work. Do not come if you have a fever, and setting the standard very clearly. But now that we're all in this mode and we all have an understanding, switching to an area where you could, or a situation where you could rely on your employees to self-screen, that may be appropriate. So there are a lot of workplaces that did not take temperatures, but instead just trained employees on how to self-screen and are relying on their employees. Any news on the 3-foot to 6-foot social distancing? Oh my goodness. That's a great question. Thank you for posting it up there. And Noah, if you want to jump in on any of these, I find them fun, so I tend to hog the Q&A a little bit. Yeah, no. Social distancing needs to be 6 feet. This has created a lot of confusion because the CDC and the schools are saying that desks can now be 3 feet apart, okay? That is simply a practical matter. They need to do it so they can get the kids back in school. It's that simple, but nothing has changed. So if those kids are sitting 3 feet apart and one of them gets COVID, the kid sitting at that desk that is not 6 feet apart has a close contact exposure to COVID. And that child would need to quarantine. So nothing has changed about our need to be 6 feet apart from each other, right? That is simply a practical step that they are taking in order to be able to get kids back in school. So no, social distancing has not been shortened to 3 feet. That has not been changed. That's a great question though, because there's a lot of confusion out there on that. How do you suggest navigating employee requests for other employee COVID test results, especially if they have worked around them or think they've been close? Well, the answer is you cannot give that at all. And the response to the employee is to say, that's confidential medical information and we don't give out other people's confidential medical information. We would do the same thing for you. Probably what's really going on there is someone hears through the grapevine that someone had COVID or that someone got a COVID test, even if it wasn't because they had an exposure, they may have just gotten one because they were going to be traveling or they were going to be at a family event. There are a lot of reasons now that people are getting tested and somebody wants to know, was I exposed? Did that person test positive? You can't share that information, but what you can do is reassure your employees that when an employee reports a positive COVID test, we go through a contact tracing process and we notify anyone who may have had a close contact exposure to that employee. But that's the best you can do. Can't give out that information. All right, I don't see any other questions popping up. So I think we will go ahead and end a few minutes early. Appreciate everyone being here and joining us for this. Noah, thank you very much for your assistance getting through all of this. And I hope you all found it to be very useful information. If you have follow-up questions, definitely reach out to us.
Absolutely. I'll offer my thanks as well. Thank you all for coming. Look forward to seeing you at the next one.